All information included herein is provided for general informational purposes by ATN Law Office. Formation basics: choosing your entity. Starting a business is exciting, but also comes with many responsibilities and decisions. One of the most important initial decisions you make is what kind of business do you want to form? Sole proprietorship, partnership, limited liability company, or corporation. Each entity has its pros and cons. Choosing what kind of entity to create depends on factors including your startup capital, if you have business associates, type of business, and business goals. Here's a summary and comparison of each entity. If you need advice specific to your situation, consult an attorney or tax advisor. Sole proprietorship. That means you are the sole owner of a business for profit. Formation. No state filing is required. You have complete personal liability. You report your profit and loss on your personal tax returns. You may be required to file the following. Just consult your tax advisor. 1. Form 1040, which is your personal income tax. Schedule SE, your self-employment tax. Form 1040-ES, that's your estimated tax. Form 941, Social Security and Medicare taxes, income tax withholding. Form W-2, this is providing information on Social Security, Medicare taxes, income tax withholding. And Form 940, which is your federal unemployment tax. You may need to file a fictitious business name statement in the county where your principal place of business is located. For a partnership, general. That's an association of 2 or more people as co-owners of a business for profit. How do you form it? There's no state filing required. You have the option to file a Statement of Partnership Authority Form GP-1. There is complete personal liability and joint and several liabilities for all partners. The partnership files an annual information return, but does not pay income tax because taxes pass through to the individual partners. Each partner reports profit and loss on personal income taxes. You may be required to file the following. Consult your tax advisor. Form 1065, that's the partnership annual return of income. Form 941, employment taxes. Form 1040, personal income tax. Schedule SE, that's the self-employment tax. Form 1040-ES, estimated taxes. For the limited partnership, that has at least one general partner and one limited partner. How do you form it? State filing is required with the Secretary of State. The general partner is the controlling partner who manages the business and makes decisions on behalf of the partnership. The general partner has complete personal liability. The limited partner has little to no rights to manage the business or to act on behalf of the partnership. The limited partner is not liable for partnership obligations beyond what the limited partner contributed. However, the limited partner may become personally liable if the limited partner takes an active role in the business. Each partner reports profit and loss on their personal tax returns, but the limited partner may not have to pay self-employment taxes. As passive business partners, the limited partner's income is not considered earned income for the self-employment tax. Limited liability company. This has the tax advantage of a partnership with the limited liability of a corporation. They are an independent legal entity, which means it has a separate identity from the founders or owners. There's no personal liability. It's governed by an operating agreement, which is kept in the internal files. Owners in a limited liability company are called members. Unless restricted by the state, members may be individuals, corporations, other limited liability companies, and foreign entities. Depending on the state, you may have a single-member limited liability company, which means there's only one owner. You're taxed depending on your election of being a sole proprietorship, partnership, or as part of the limited liability owner's tax return as a disregarded entity. C Corporation. That's an entity providing limited liability protection with the power to raise unlimited capital from shareholders. It's an independent legal entity, which means it has a separate identity from the founders' owners. Formation. Filing is required with the Secretary of State. There's no personal liability unless the corporate veil is pierced. The C Corporation is governed by bylaws, which is kept in your internal files. You must hold annual meetings and record your minutes for your internal files. There's no limit on the number of shareholders, and you can report your profit or loss at the corporate level, and you can report your dividends to your shareholders on the personal level. You may be required to file the following forms. Consult your tax advisor. Form 1120, your corporate income tax. Form 1120W, your estimated corporate tax. Form 941, your employment tax. And let's talk about the S Corporation. This provides limited liability protection without double taxation, having the tax advantage of a partnership. Like the C Corporation, the S Corporation is an independent legal entity, which means it has a separate identity from the founders' owners. Formation, filing required with the Secretary of State. There is no personal liability unless the corporate veil is pierced. It's also governed by bylaws, which is kept in your internal files. You also must hold annual meetings, record minutes for your internal files. You have to elect to be an S corporation, and the requirements are you have to be a domestic corporation. Your shareholders may only be individuals, certain trusts and estates, U.S. citizens, or residents. You can have no more than 100 shareholders, and you can only have one class of stock. You report your profit and loss on your personal tax returns. You may be required to file the following documents. Consult with your tax advisor. Form 1120S, Schedule K1, Income Tax. Form 1120W, your estimated tax. Form 941, your employment tax. For shareholders, Form 1040, Schedule E, and other forms that may be referenced on the shareholders K1. If you have more questions, consult an attorney. Remember, planning is the first step in preparing for your future.